Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law Number 2. This morning, we have two dockets. We have a motion to revoke probation docket, and we have the announcement docket. When I call your name, please come forward with your attorney. If your attorney is not here, we'll wait for your attorney to arrive because your attorney may be in another court handling another matter. If you are not represented by an attorney, when I call your name, please come forward by yourself. Miss Holmes. David Abel Rowe. Your name is David Abel Rowe? Yes. Okay. Hold on a minute. Okay, Mr. Rowe, you were in court on January 7th. Okay. Of 2025. On that day, you indicated to the court that you wanted your case reset to give you time to hire an attorney. Is that correct? Have you hired your attorney? Why haven't you hired your attorney?
The thing is, I got attack, like people attack me.
You got attacked?
Yeah.
Okay,
So I go to hospital.
okay,
And, so that's what I'm gonna come there.
okay. So how are you doing now? You all right? You
Yeah,
recovered from
yeah.
the attack? Okay, okay,
Feeling better. But
Okay.
that's what I'm gonna work like for maybe 3 weeks to bring up my number.
okay. So you need some more time to,
Yes.
Okay. Let's give him a reset. Okay, this case will be reset to June 11th, 2025 at 9 a.m. To give you time to hire your attorney. Our court coordinator is going to give you your reset. Once you get your reset, you'll be free to go, and you have a blessed day. And it's good that you have recovered. You fully recovered.
Yeah.
Okay, well that's good.
Yeah, I'm gonna start to make money, remember, that's what I said.
Okay.
For you, that's, I
Okay.
think you will give me time.
Okay, all right. You can get your reset and you'll be free to go. And you have a blessed day. Ms. Mosby.
Yes, sir.
Um, Sydney Alexander Shedley. There's a lot of conditions. He does?
Thank you. It's,
Well, let me see.
people shouldn't,
Let me see. Shedley.
the tracking device.
Yeah, I know. Shedley. Oh, I'm thinking about you.
Yeah.
Okay. I'm like, cause I was trying to look, I was trying to look it up by your name,
Right.
but I was saying Shedley and I didn't see a Shedley in the list of attorneys. Okay. Let me see what the This must be his first time here.
No, he's been here before.
He has?
Yeah. Why?
I see your attorney rep letter. I see the notice just warning. Oh, that's from 24.
We about got it worked out, Judge. We just need one more reset. I just need to talk to Andrew about a couple things.
Yeah,
Probably gonna be a JP. I'm hoping you can JP.
Yeah.
it.
let me do this here. Okay. Okay, this is cause number 24CCC Aura 2564. Case of style, the state of Texas versus Sidney Alexander Shetley. Mr. Shetley, is that your full name? How are you doing, Mr. Shetley? I'm doing fine, thanks for asking. Mr. Shetley, you're represented in your case by your attorney, Attorney Alan Parker. Attorney Parker, how are you doing?
Good, Judge.
And Mr. Parker, what is your announcement in Mr. Shetley's case?
We need one more reset, Judge. We need to relay some information, discuss with the prosecutor about how we can resolve this. I think it'll help.
Okay. Give us a reset date. June 11th. Okay, Mr. Shetley, this case will be reset till June 11th of 2025. You'll be given a copy of your reset by our court coordinator. Once you get a copy, you'll be free to go. But before she gives you the copy, I need to give you some standard bond conditions in this case. And you'll be able to get a copy of this document from the coordinator. The document states, following return of criminal information in County Court at Law Number 2 of Jefferson County, Texas, all real bonds executed for release of any defendant named herein or orders subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol and the test indicates the presence of drugs or alcohol in the defendant's body. Do you understand that condition?
Yes.
And condition number 3, the defendant shall not communicate either directly or indirectly with the alleged victim or the pending offense, and the defendant shall not go near any residence, school, or other location frequented about the alleged victim. You understand that condition? Now, condition number 4 only applies in the DWI, and it doesn't apply in this case.
What?
Oh, I don't have any,
No,
He
I
said
said,
it doesn't apply.
I say it doesn't apply. I said it only applies in a DWI case. Your case is not a DWI case. Now, if you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, the warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County jail.
Judge, man, why would you have a condition on there that he can't have beer or drink a beer or something?
These
Because
are,
it's not an alcohol related crime. It's not DWI. I mean, it's not illegal to drink
Okay.
a beer and it's not
I don't think the word beer is anywhere on this.
alcohol. Beer is
No,
alcohol.
listen to what I said. I said that the defendant shall submit to testing for drugs and alcohol at any time as directed by the court.
Right.
Okay. The court has to ask for him to submit to a test first. I'm talking about a test. I didn't say he couldn't drink.
Well, I know, but it says if you
I
test
say
positive for drugs or alcohol.
if the court asks you to take a test and you submit to the test, and the test indicates that you have drugs or alcohol in your system, or if you refuse to take the test, the court can revoke your bond. That's what it's saying.
I understand.
These are standard bond conditions. They posted on our website, and these are standard conditions for all 4 of the criminal courts.
But what I'm saying is that in essence, you're saying you could call him up at 5 o'clock in the afternoon, said, you need to go get tested. He got off work before and he had 2 or 3 beers and he had alcohol in the system, you know? I'm just saying, you know, it's realistic and if it's, but so if it doesn't
Yeah.
apply, it shouldn't be a bond condition. I mean,
Well,
that's at your discretion.
No, these are the judges, the criminal judges bond condition. It's a standard bond condition.
Yeah.
This is just not my bond condition. This is every criminal court
But you
bond
can-
condition. And these, we enforcing the bond conditions that's been approved by all the courts, all the criminal courts in Jefferson County. Now, if you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, a warrant will be issued for your arrest. You'll be arrested and placed in Jefferson County Jail. Do you understand? Okay. You could, make a copy to see, you'll be able to get a copy. Once you get a copy of your reset and your bond conditions, you're free to go and you have a blessed day. Right.
Yes.
Okay. It's a, I think that please arrest me, but it's just that he did it first.
Yeah.
I don't know why.
That's what you kept saying there was being, reduced, but I didn't see anything on our end that said it was anything other than first.
Check information, and it's just the DWI first. Okay, I just want to make sure. There, let's get more than route.
Okay.
And we have just. Taylor. But, yeah.
Okay. Jefferson County Court at Law number 2 is back in session. Court is in session and cause number 24 CCCR 1867. Case is style the state of Texas versus Alonzo Martinez Jr. Mr. Martinez is appearing via Zoom. Mr. Martinez, how are you doing?
I'm good, Your Honor.
Oh, that's good. Now, Mr. Martinez, you're represented in your case by your attorney, Attorney Dustin Galmore, who is present in court. Mr. Galmore, how are you doing?
Good, Judge.
That's good. Mr. Galmore, well, the state is represented in this case by Attorney Shane Hilton. Attorney Hilton, how are you doing?
I'm good, Your Honor. Thank you.
And Mr. Galmore, what is your announcement in Mr. Martinez's case?
Judge, on Mr. Martinez's case, we've received all the discovery, just haven't finished reviewing it all. If we get one more announcement.
Okay, discovery. Give us a read. June 11th. Okay, this case will be reset to June 11th, 2025. Mr. Martinez, your attorney and your bondsman will be given notice of your reset. Stay in contact with your attorney, your bondsman. Your case has been reset to June 11th, 2025 at 9 a.m. You're free to go and you have a blessed day.
Thank you. You too, sir.
Thank you. Justin Andrew Taylor. Mr.
Yes.
Taylor is appearing via Zoom. Mr. Taylor, how are you doing?
I'm doing great, Judge. How are you today?
I'm doing fine. Thanks for asking, Mr. Taylor. You're represented in your case by your attorney, Attorney Dustin Galmore, who is present in court. Mr. Galmore, what's your announcement in Mr. Taylor's case?
Judge, a similar announcement. I know we've received all the discovery, but this is a newer case and I haven't had a chance to watch the videos yet.
Okay, give us the reset date. Okay, this case will be reset to June 11th, 2025. Mr. Taylor, your attorney and your bondsman will be given notice of your reset. Stay in contact with your attorney and your bondsman. You're free to go. And again, this case is reset June 11th, 2025 at 9 a.m. And you have a blessed
Yes.
day.
Yes, sir, Judge. You too.
Okay. Arthurius Quentin Holman.
Judge, he contacted me and said he was having difficulties with the Zoom, but he's working on it right now. So I'll wait a few minutes. I think he should be on there any second.
Okay. Okay. Daniel Douglas Quibido.
Okay.
Mr. Quibido. Your full name is Daniel Douglas Quibido. How are you doing, Mr. Quibido?
Pretty good. Yourself?
I'm doing fine, thanks for asking. Mr. Quibido, you're represented in your case by your attorney, Alan Parker. Attorney Parker, do you waive a record in Mr. Quibido's
You
cases?
do, Judge.
Mr. Quibido, in cause number 24 CCCR 1868, I have before me a document that is titled Information. This Okay. And, Mr. Quibido, the document that I have before me is titled, information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Daniel Douglas Quibido, on or about July 4th of 2024, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of driving while intoxicated while you were operating a motor vehicle in a public place in Jefferson County, Texas. Mr. Quibido, do you understand what you have been charged with?
Yes, sir.
To this charge, how do you plead? Guilty, not guilty, or no contest?
No contact.
Are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges? Mr. Quibido, I also have before me a document that is titled Misdemeanor Plea Admonishments. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there are a set of initials, DQ, on a line next to a box that's checking the contendere, which means no contest.
sir.
Did you place your initials on this document? On page 3 of the same document, there's a signature above the line that's titled defendant. Is this your signature?
Sir.
And on the next document that's titled trial court certification of defendant's right of appeal, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes, sir.
The second box that's checked states that you are waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes, sir.
You had a discovery certification? I also have a document that is titled Discovery Certification. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled defendant?
Yes, sir.
Mr. Quibido, before you signed and initialed these documents, did your attorney go over these documents with you?
Yes, sir.
Did you understand everything that your attorney went over?
Yes, sir.
Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Quibido, are you a citizen of the United States?
Yes, sir.
State offer States Exhibit 1, Your Honor.
No objection.
No objections. State's exhibit number 1 will be admitted. Mr. Parker, you've advised and counseled Mr. Quibido. Is there any evidence that he is currently mentally incompetent to stand trial?
No, Your Honor.
And Mr. Quibido, your attorney, Mr. Parker, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Mr. Quibido, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I'll also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is the agreement?
Your Honor, we'd ask the court for 180 days county jail, probated for a period of 12 months of community supervision. That's for a fine of $500, repayment of court costs, 60 hours of community service with the standard DWI first terms and conditions of probation. And then in exchange for a plea to this charge, the state agrees to dismiss the companion case, cause number 24CCCR 2284.
What is this court cost? $392?
Yes.
Hmm? Okay. Mr. Quibido, the state is offering that you serve, is that,
180,
oh, that's what they, oh.
180 days.
Yeah, couldn't read it. Okay. Mr. Quibido, the state is offering that you serve 180 days in the Jefferson County Jail. However, you will not be required to serve any time in the Jefferson County Jail because you will be on probation for a period of 1 year. During the 1 year probationary period, you'll be required to pay a fine of $500 plus court costs of $392. You'll be required to pay a DWI conviction or fine slash fee of $100. You'll be required to pay probation fee of $60 a month, urinalysis fee of $15 a month, reimbursement fee of $15. You'll also be required to pay Jefferson County DWI education and initial evaluation fee of $125 on the day of the police. Should a further evaluation be needed, you'll be required to pay an additional $50. Now, your total monthly installments, that is a total amount that you will be required to pay each month, is $173 a month. Will you be able to pay the $173 each month?
Yes, sir.
You will also be required to perform 60 hours of community service. You'll be required to adhere to the other standard terms and conditions of this DWI probation. And the state will be dismissing the companion case, cause number 24 CCCR 2284. Mr. Quibido, do you understand the state's offer?
Yes, sir.
And do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Mr. Quibido, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Quibido, this will conclude your case. You will stand next to the bailiff, follow her directions, and now that goes here. You follow her direction. Once you finish following her directions, you'll be free to go. And you have a blessed day. And Mr. Parker, you're free to go as well. You have a blessed
Your Honor,
day.
he has a drug patch on. Can he just pull the drug patch off? Does he need to go get it removed?
Who ordered the drug
It was a
patch?
condition of the bond on the other case.
The one that it getting dismissed.
Hold on a minute.
He had a possession of a controlled substance, which was basically a prescription. That was, he was told at the jail that he needed to do that when he bonded out. So that's why he put it on.
Yeah, they wouldn't let me get bonded out without having it on.
I think they thought it was gonna be a felony, so,
Hold on, because we didn't, I mean, I don't have an order to,
yeah, okay,
well, let me make sure. He said he had a drug patch?
right.
Hold on, let me, you said I was in the other case? Come on.
Yes, it was in the,
It was in the drug case? Hold
yeah, it
on.
was done at the jail.
Magistrate's warning, return. Let me see what they, if he put an order in.
I don't know if they typically don't put an order, they just tell you. I'm just telling you, I mean, I know, and he's one of the few that obeyed the order,
Oh, wow, it was,
just rip it off.
yeah, well,
I mean, they can't do, they dismiss, in case you dismiss, there's nothing they do about it.
well, I miss, hold on, wait, I saw something say bond conditions. No, that said cash bond. Hold on, that said cash bond.
They can't do anything because they're dismissing the case, so they can't. I mean, that's not a condition of
Okay, let me
bond, it's not a
see.
bond.
Yeah,
Forget I asked. I mean, it is.
hey, I don't see condition in here, I mean,
But the problem, the jail probably.
That's,
yeah, but it has to be it was, I don't see an order where he was,
they typically don't put an order, they have no way of putting an order in the file when they get arrested. They're very seldom done, even though, like people who have bond conditions, they are given.
oh, here it is. Yeah, it said he must have drug patch. That was signed by Judge DeRuin.
Mhm.
So you just we can do an order for him to where it will come off.
Okay,
So you want
We just do an order for it to be released, that condition, the bond condition. He's no longer under the bond conditions. Okay, so what we'll do, we'll draft one up today and sign it. Okay, so it'll be in the file. Okay,
Go back to the building. Put out this. Resign.
okay. This is cause number 24CCCR 0874, case of style of state of Texas versus John James Laurie. Mr. Laurie, is that your full name?
Yes,
How are you doing, Mr. Laurie?
very tired, worked 18 hours.
Okay, okay,
Having trouble staying awake.
okay. Now, Mr. Laurie, you're represented in your case by your attorney, Attorney Nathan Reynolds. Attorney Reynolds, how you doing?
Doing well, Judge, thanks.
Okay, and Mr. Reynolds, what is your announcing in Mr. Laurie's case?
Mr. Laurie has a pending felony case. This is about 252nd. And it has been reset until May 29th. And we'd ask that this case be. set-
May 29th?
Yes, sir.
We will, Mr. Gurr, Mr. Gurr, this is Mr. Laurie. We're gonna reset this case with his felony case, which is set for May 29th, 2025. Okay? Okay, so you're gonna get your reset from our coordinator. Once you get your reset, you're free to go now on May 29th. You need to come and check in with our bailiff first, and then go take care of your felony case, and then come back here to let us know. All right? So, and Mr. Reynolds, this is your only case?
Yes, sir.
You're free to go as well. You have a blessed day.
Thank you so much.
You welcome. You will get your reset. You can get your reset. Okay, you're free to go and you have a blessed day. And we can call Miss Kaufman's case. Person didn't. And yeah. Oh, I had called Miss Kaufman's case. Is she here? Okay, you good, okay. Okay. Shawana Collier,
Yes, Your Honor, she's present.
Ms. Collier, your full name is Shawana Monique Collier? How you doing, Ms. Collier? I'm fine. You don't have to put your hand, I'm not sworn you. Okay. Now, Ms. Collier, you're represented by your attorney, Kevin Lane, Attorney Lane. How are you doing?
Fine, Your Honor, thank you.
That's good. And Ms. Collier, again, how are you doing?
All right.
That's good. Now, Mr. Lane, what is your announcement in Ms. Collier's case?
Your Honor, we're just asking for one more announcement. We've received the offer, we received discovery, but I'm trying to locate the videos. I went to check them out yesterday, and they weren't there, but I didn't see an email of those. So just, we need to see the videos.
Okay, give us a reset date. June what? 18. Okay, this case will be reset for June 18, 2025. Ms. Collier, you get your reset from our coordinator. Once you get your reset, you'll be free to go. You have a blessed day.
Thank
And
you.
Mr. Lane, this is your only case?
It is.
Okay, you're free to go as well. You have a blessed day. Thank you.
I mean,
Miss, that must be Mr.
Yes, Mr. Briggs, I already let Mr. Jack know.
Okay, the person that's on Zoom that has iPhone, would you please take your mic off of mute and state your full name?
Darius Holman.
Holman? Okay, Ms. Holman? Okay, you're represented by Dustin Galmore, is that correct?
Yeah, he said.
Yes, sir.
Okay, hold on a minute.
He let me know. He's right. AMG.
I have a case going right now. I'll get to you next. Mr. Wait for the bottom. Yeah. Prosecutor, okay. Now, this is cause number 24 CCCR 2226. Case is style of state of Texas versus Arthurius Quentin Holman. And Mr. Holman is appearing via Zoom. Mr. Holman, how are you doing?
Good. How you doing?
I'm doing fine, thanks for asking. Mr. Holman, you're representing your case by your attorney, Dustin Galmore. Mr. Galmore, what is your announcement in Mr. Holman's case?
Judge, we just need another announcement date to see if we can find a resolution in this matter.
Okay, we're gonna reset this on June 11 with the other two, his other two cases. Okay. This case will be reset to June 11th, 2025. Mr. Holman, your attorney will be given notice of your reset. Your case is reset for June 11th, 2025. Stay in contact with your attorney. You're free to go and you have a blessed day.
All right, you too.
Thank you, Judge.
Okay, you're welcome.
All right, thank
You're welcome. You're free to go. You have a blessed day.
you too.
Thank you. Ms. Carlton, you have,
Yes, Your Honor, she is, I talked to her on the phone, she says she's 10 to 15 minutes.
okay, we'll hold. Mr. Boudreaux? Mr. Boudreaux? Shanisha Mims? Miss, you working on anything? Okay. Miss Mims, your full name is Shanisha M. Mims?
Yes, sir.
How you doing, Miss Mims? That's good. Miss Mims, you're represented in your case by your attorney, Attorney Don Boudreaux. Attorney Boudreaux, how are you doing?
Just fine, sir.
That's good. Now, Mr. Boudreaux, what is your announcement in Ms. Mims' case?
Your Honor, I didn't think this was possible, but I got appointed on the DWI. The district attorney's office has decided to file an evading arrest, and that's in Judge Stevens' court, and it's set for May the 28th or 27th.
May 28th.
28th.
Yeah, I
May
have that on the
28th.
docket.
So I guess we need to wait on,
Are they out of the same criminal episode? Would have been,
I believe so, Your Honor.
okay. So this is a new case. Okay. So we will reset this case along with your felony case
Yes.
on May 28th, 2025. You'll be able to get a copy of your reset from our coordinator. Once you get a copy of your reset, you'll be free to go. Stay in contact with your attorney and your bossman.
Yes, sir. And also, can I ask you about, I noticed that like my license was flagged, but they gave me, my license. Driver's license.
What about your license?
Like it was flagged. I think this says something like LR on it. I don't know.
Oh, she's probably talking about an ALR hearing. That she must have. Yeah, you can talk to your attorney about that.
Okay.
Driver's license suspension hearing. Yeah. Okay.
stand over here. So
Okay, you can get your reset. Once you get your reset, you're free to go and you have a blessed day. And Mr.
I think-
Boudreaux, is this your only case?
I don't think there's anything else, sir.
That's it. So you're free to go as well. And you have a blessed day. You get your reset from our coordinator. Okay.
I don't work.
Jefferson County Court at Law number 2 is back in session. The court is in session in 5 cases. They are cause number 24 CCCR 2377, cause number M333 694, cause number M333 690, cause number 24 CCCR 2415, and cause number 24 CCCR 2414. All 5 cases are styled the state of Texas versus Melissa Noel Van Loot. Ms. Van Loot, is that your full name?
Yes.
How are you doing, Ms. Van Loot? That's good. Now, Ms. Van Loot, you appeared in court on March 25th of 2025. And on that day, the court read to you 2 motions of revoke probations. One was in cause number M333 694, and the second motion to revoke probation is cause number M333 690. And on that day, you signed a judge's explanation of rights to defendants without attorney. And at that time, you requested that your case be reset to give you time to hire your own attorney in these cases. Have you hired your attorney?
Sir, I spoke with one over the phone and he gave me options and said I could come and find out what would be offered from the prosecutor or the state, and then I could decide at that time.
Okay, let me do this here now. In the judge's explanation that we gave to you on March 25th, it stated that you may not speak to the prosecutor about your case unless you sign a written waiver of your right to be represented by an attorney. So if you would like to waive your right to be represented by an attorney, you have to sign a waiver, and then you would have to change your choice on the judge's explanation. You have to change it from I want to reset this case to hire my own attorney to I want to waive my right to an attorney and represent myself. Do you understand?
Yes, sir. Am I allowed to change my mind again to say I want to hire an attorney if
Okay.
I
The
can't?
last sentence in the judge's explanation, she has a judge's explanation before her. It says, if you proceed without an attorney, you may change your mind at any time and may request counsel from the court. Do you understand that? Okay. So you have a clipboard, some paperwork on it. You can read the judge's explanation, make your choice. And if you choose to waive your right to an attorney, you can read and sign the waiver that's titled Waiver of a Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. Okay, you can have a seat. We'll give you time to go over those documents and make your choice. You're welcome. Ms. Kaufman's client showed up. This is cause number 25 CCCR 0278. Case is style of state of Texas versus Tanya Yvonne Skidmore. Would you please stand in? Ms. Skidmore, is that your full name?
Yes,
How are you doing, Ms. Skidmore?
blessed.
Okay, you can't be better than being blessed. That's the best thing that can happen to you. Now, Ms. Skidmore, you're represented in your case by your attorney, Christy Carlton. Ms. Carlton, how are you doing?
I'm doing well, Your Honor.
That's good. Now, Ms. Carlton, what is your announcement in Ms. Skidmore's case?
My announcement is the prosecutor that has the case is not here, so we do not have an offer in the case, and I have not been able to go over discovery with my client. She's been in and out of the hospital. So we're asking for a reset.
Okay. June 11th was. And how are you doing today, Ms. Skidmore? And you say you're blessed?
More blessed than I deserve.
Okay, that's good. It's a good thing that you realize that. Some people don't realize
I
that.
don't complain about it.
You gotta count your blessings.
We can do June
June 11th, okay. Now, Ms. Skidmore, your case will be reset to June 11th, 2025. You're gonna get your reset from our court coordinator. Once you get your reset, you'll be free to go. And you continue to have a blessed day, Ms. Skidmore. We'll pray for you that you have a full and complete recovery. Okay? All right, and you have a blessed day. And Ms. Carlton, you're free to go as well, and you have a blessed day.
Thank you, Your Honor. Have a blessed day.
Okay. All right.
Thank you.
Yeah. Now, Mr. Jones, the court has just received word that the reason why your attorney is not here is because your attorney is sick. And so your case has to be reset for your attorney to be here, and you could be here with your attorney. Let me ask you. Let me do this. I'm gonna put this on mute. So your case will be reset for 2 weeks. You're gonna get your reset. Once you get your reset, you'll be free to go. And you have a blessed day. All right. Wilkerson. Wilkerson. Okay, you're welcome. Okay. Okay, sir, who is your attorney? Oh, Ruben Cartwright? Your attorney is on his way. Okay.
Dan John's, no.
Yeah, it's worse. Okay. Hold on a minute. Court is in session in cause number 24 CCCR 2880. Case is styled the state of Texas versus Daniel J. Briggs. Mr. Briggs, is that your full name?
Yes, sir.
Mr. Briggs, would you please raise your right hand? Mr. Briggs, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Briggs, you may put your hand down. How are you doing, Mr. Briggs?
Yes, sir.
I'm doing fine, thanks for asking. Now, Mr. Briggs, you're represented in your case by your attorney, Attorney Jack Lawrence. The third, Mr. Lawrence, how are you doing?
Just fine, Your Honor.
That's good. Now, Mr. Lawrence, do you waive a record in Mr. Briggs' case?
Yes, we do, Your Honor.
And Mr. Briggs, I have before me a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Daniel J. Briggs, on or about November 13th of 2024, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of criminal trespass of a habitation. Mr. Briggs, do you understand what you have been charged with?
Yes, sir.
To this charge, Mr. Briggs, how do you plead guilty, not guilty, and no contest? Are you pleading no contest freely and voluntarily? And are you pleading no contest because you do not wish to fight or contest the charges?
Correct.
Mr. Briggs, I also have before me on my tablet a document that is titled Misdemeanor Plea Admonishment. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there's a set of initials on a line next to a box that's checked nola contendere, which means no contest. Did you place your initials on this document?
Yes, sir.
On page 3 of the same document, there is a signature above the line that is titled defendant. Is this your signature?
Yes, sir.
And on the next document that's titled Trial Court Certification of Defendant's Right of Appeal, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes, sir.
The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes, sir.
Do we have a discovery? Well, matter of fact, you only have 1 box that's checked. The box that's checked states that this is a plea bargain case and you have no right to appeal. Do you understand that?
Yes, sir.
Now, is there a discovery certification?
I'll do one now.
Oh, okay. Mr. Briggs, I have before me a document that is titled Discovery Certification. Do you recognize this document? Is this your signature on the line that's titled defendant?
Yes, sir.
Now, Mr. Briggs, before you signed and initialed all of these documents that I just showed you, did your attorney, Mr. Lawrence, go over these documents with you? And did you understand everything that Mr. Lawrence went over?
Yes, sir.
Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Here you go. Mr. Briggs, are you a citizen of the United States?
Yes, sir.
State offer States Exhibit 1, Your Honor.
Do you have any objections to State's Exhibit number 1?
None, Your Honor.
Okay, no objection. State's Exhibit number 1 will be admitted. Mr. Lawrence, you've advised and counseled Mr. Briggs. Is there any evidence that he is currently mentally incompetent to stand trial?
No, Your Honor.
And Mr. Briggs, your attorney, Mr. Lawrence, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Mr. Briggs, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, Your Honor.
And what is the agreement?
Your Honor, we'd ask the court for 180 days county jail, probated for a period of 12 months of community supervision. That's for a fine of $300, repayment of court costs, and 30 hours of community service. And as a condition of probation, we'd ask that be no contact with the complaining witness, Paulette Gidros.
Okay. What is the court cost?
277.
277? 350. Oh, okay. 277.
If it would help any on calculating these fees, he is trying to go back and get his GED.
Okay, well, yeah, I need to calculate the fees first.
All right.
Yeah, we'll get this. Okay, now, Mr. Briggs, the state is offering that you serve 180 days in jail, but you will not be required to serve any time in jail because you'll be placed on probation for a period of 1 year. During the 1 year probationary period, you'll be required to pay a fine of $300 plus court costs of $277. You'll be required to pay a probation fee of $60 a month, urine fee of $15 a month, reimbursement fee of $15. You'll also be required to pay Jefferson County court-appointed attorney's fees of $350. Now, your total monthly installments, that is the total amount that you will be required to pay each month while you are on probation, is $167 a month. Will you be able to pay the $167 a month?
Yes, sir.
All right. You will also be required to perform 30 hours of community service. You cannot have any contact with a Paulette Gidros, and you will be required to adhere to the other standard terms and conditions of your probation. Do you understand that?
Yes, sir.
Now, Mr. Briggs, do you understand the state's offer?
Yes, sir. I do.
Do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes.
Okay, Mr. Gidros, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Gidros, you will stand next to the bailiff, follow her directions. Once you finish following her directions, you'll be free to go. I mean, Mr. Briggs, once you finish following her directions, you'll be free to go. And you have a blessed day. Please stand at the, yes.
My mother was asking me about, cause she helped me bond out, we did a cash bond.
Oh, you should be, if there's a cash bond, you get that bond, they'll be able to get that bond back.
So do I go to the jailhouse?
No, 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 no.
Yes.
It's down in the county clerk's office.
Okay.
I think you bring a
Cool.
judgment, identification. If she paid for it, she might have to be with you because they'll have the, the paperwork will show that she paid for it.
Okay, cause she was telling me they told her it'd be a check in my name to bring it to them when I finish.
Oh, I don't know.
Yeah.
But you're gonna bring your paperwork downstairs
Yes, sir.
to the clerk's office. And they'll tell you what they need.
I'll go with you.
Okay.
Thank you.
Okay, you're welcome.
I'm sorry,
Okay, Miss Lane,
Hello.
would you please come forward? Okay, this is cause number 25 CCCR 0206. Case is style of state of Texas versus Ashley Renee Lang. Is it Lange?
Lang,
Lang.
yeah,
And how are you doing, Miss Lang?
I'm grateful.
Okay, that's good. Ms. Lang, you're represented in your case by your attorney, Attorney Giles Cole, Attorney Cole.
Judge, can you hear me?
Yes.
I can't hear you.
Okay.
I can't hear anybody.
Okay, you might have to turn your, you might have to call him and tell him to turn his deal off and Zoom back in.
Who's that, John?
Yeah. You know, tell him we can hear him. Hmm? Oh.
They're gonna bring Rob.
But she can't do anything today. Okay.
He's on mute. But a mute would mean, he like he froze. No, he's still out. Oh, no, he's there.
Yeah.
Cause I saw his eyes blank. We need to tell him that he might have to get off and get back on Zoom. He must not have it because he just turned it off of mute. I can see it when it comes on the mute because they're red. Oh, yeah. Okay, the person that has Motorola Moto on Zoom, please take your mic off of mute and state your full name. Yeah, Giles, can you hear us now?
Can hear you now, Judge. I'm on my phone.
Okay. This is cause number 25 CCCR 0206. Case of style of state of Texas versus Ashley Renee Lang. We have Miss Lang present in court. Miss Lang, how are you doing?
Grateful.
That's good. Now, Miss Lang, you're represented in your case by your attorney, Attorney Giles Cole, who is appearing via Zoom. Mr. Cole, how are you doing?
Doing great, Your Honor. How about yourself?
I'm doing fine. Thanks for asking. Now, Mr. Cole, what is your announcement in Miss Lang's case?
Me and Ms. Lang have yet to get together, Judge. We need to talk. So if I could have time to get with her and go over things.
Okay, we're gonna give us a reset. Okay, this case will be reset to June 18th, 2025. Ms. Lang, you're gonna get your reset from our court coordinator. Once you get your reset, you'll be free to go and you have a blessed day.
Your Honor,
Yes, hold on.
could you please have Ms. Lang to call the office number that's on the reset notice so that way we can get her situated?
Yes, sir.
Okay, there's they're gonna give you a reset. His office number will be on that reset.
Yes, sir.
All right?
Yes,
Once
sir.
you get your reset, you're free to go and you have a blessed day.
You as well, Judge.
All right, you're welcome.
Thank you.
And Mr. Cole, your reset will be sent to you.
Thank you, Your Honor.
Okay.
Yes, sir. My big excuse.
Yes, you may be excused and you have a blessed day.
You do the same.
Melissa Van Loo? Now, Ms. Van Loo, I have three documents before me. You have one is the judge's explanation of rights to defendants without attorney. And then the, did you scratch out the part that said you wanted to waive your right? And then you put your initials in the one that you wanted to apply for court appointed counsel? That's it? Okay. Okay, Ms. Van Loo, would you please raise your right hand? Ms. Van Loo, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth shall be God?
Yes, sir.
You may put your hand down. Now, Ms. Van Loo, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
And are these your initials on the line that states you'd like to apply for court appointed attorney?
Yes, sir.
I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there's a signature above the line that is titled defendant signature. Is this your signature?
Yes, sir.
Now, Ms. Van Loo, before you sign and initial these documents, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Let me do this here. I need to ask you some information.
Your Honor. Can you hear me, Your Honor?
Yeah, we can hear you, but I have somebody at the bench right now. We'll call your case next. Okay, just hold on. We'll call your case next. Okay, Ms. Van Loo, court found that you meet the eligibility requirements for the appointment of court-appointed attorney. Attorney that will be appointed to represent you is Attorney William Wilkerson. Attorney Wilkerson will be given information to contact you. Will also give information to contact him. Our court coordinator will give you that information. Once you get that information, you'll be free to go. And you have a blessed day. Please stand in front of the coordinator.